dia a todos. É um prazer estar aqui hoje com todos vocês moderando esse painel. Queria agradecer aí ao IBRAC, nas pessoas do René, do Rafael, da Juliana e da Maria Clara também, que ajudaram a organizar esse painel. Como o senhor adiantou, a gente vai fazer esse painel em inglês, então eu vou pedir licença para já conduzir em inglês. So, switching to English now, thank you very much, all of you, for joining us here this morning. I'll make a brief introduction and also from each of you so we can get started with the discussions. So I think that it's been presented before. This is a very important topic, a hot topic at the moment, and I think we have a very good opportunity here to discuss, the implications of what have been discussing in the U.S. and here to the Brazilian companies too. So the topic of the panel is pause and unpause in the FCPA enforcement, impacts and perspectives for companies in Brazil. As just to set the stage for the discussions and introductions, I'll just say that, as you all know, the FCPA was enacted in 1977 for the purpose of making it unlawful for certain classes of persons and entities to make payments to foreign government officials to assist in obtaining and retaining business. Since 1977, the anti-bribery provisions of the FCPA have applied to all U.S. persons and certain foreign issuers of securities. And with the enactment of certain amendments in 1998, the anti-bribery provisions of the FCPA also apply to foreign firms and persons who cause, directly or through agents, an act in furtherance of such a corrupt payment to take place within the territory of the United States. For decades, the FCPA has inspired and has been inspiring many other legislations around the world to prevent and combat corruption. On February 10, 2025, President Donald Trump issued an executive order to pause FCPA enforcement for a period of 180 days and determined the Attorney General to review guidelines and policies governing investigations and enforcement actions under the FCPA. On June 9 this year, the Deputy Attorney General, Todd Blanche, also issued new guidelines for investigations and enforcement of the SPA to ensure that the FCPA investigations and prosecutions are carried out in accordance with the President Trump's directive by, 1, limiting undue burden on American companies that operate abroad, and 2, targeting enforcement actions against conduct that directly undermines U.S. national interests. Which are these new guidelines? What do they represent in practice? What U.S. and Brazilian and other multinational companies doing business in the U.S. and elsewhere should be aware of? So the purpose of this panel is to address some of these and other questions. And for that, we have a group of very distinguished panelists here, which I'm glad to introduce to you. So first, on my right here, we have Reynaldo Goto, who is a Chief Compliance Officer at BRF. Reynaldo has large experience as in-house in compliance offices at multinational companies in Brazil, and is a seasoned speaker in conferences in Brazil and worldwide for topics related to compliance and anti-corruption. On my left here, you have William Devaney, we'll call Witch, yes, right? Who is a partner and co-chair of Global Compliance and Investigations at Baker McKenzie. He's also a former federal prosecutor in the US, an experienced trial lawyer. Witch also routinely represents clients in complex civil and litigation and provides compliance advisory advice, particularly in the anti-corruption sphere. And for last but not least, Raquel de Mattos Pimenta is a professor at Fundação Getúlio Vargas, São Paulo Law School since 2021. She holds a PhD and master degrees in economic law and political economy from the Law School of the University of São Paulo, with visiting research periods at Yale and Georgetown in the US. Her research agenda addresses the areas of law and development, corruption, public policy, and political economy. So the way we thought about this panel, I'll give the floor to each of the speakers to make a brief introduction on the topics they would like to address. We set the stage there, and then we have rounds of questions here, and I would encourage the audience to raise your hands during the Q&A section to raise your own questions too. So I will start with you, Rich, so if you could set the stage for us, and thanks again for coming here for this panel.
Oh, not at all, my pleasure, and I'm glad you found a high school photo of me, Fabricio, to put up there. Another decade or two of the practice of law has taken its toll, as you can see. So I think not to bury the lead, as they say, overall, post this FCPA pause, enforcement will be down, and I will get into the reasons why. To the extent there is enforcement, and there will be, it will mainly be against non-US companies, I believe. But I still think that level will be lower than what it once was. So what should you do differently? Nothing at all from a compliance standpoint. And we'll get into the many multi-layered reasons, but number one among them is the statute of limitations is 5 years. There's 3.5 years to go in this administration. So it's not an opportunity to ease up on compliance at all. And we can talk about much of this in more detail. So to take a step back from Fabricio's excellent introduction of the topic, the pause in the FCPA began in February, as Fabricio mentioned, but it began with a memo from the Attorney General Pam Bondi on the 5th, in which she sort of laid out this administration's concerns a bit in that memo. And remember, President Trump campaigned on, from a criminal justice standpoint, it's immigration and drugs over and over and over again. And that memo laid out that the FCPA unit was going to be pivoted toward transnational criminal organizations, in other words, mostly drug cartels. That makes no sense. There's a myriad of laws out there to prosecute transnational criminal organizations, whether they're narcotics organizations or terrorist organizations. There are many better laws to go after them. And in fact, trying to put an FCPA wrapper on it is really nailing a square peg into a round hole. That prosecutors would have a very difficult time doing that. That does add a layer of risk, which I'll come back to in a bit. And then the administration also suggested that the enforcement of the FCPA was unfair to US businesses that couldn't compete against non-US companies that were paying bribes, which is kind of interesting since 9 out of 10 of the largest FCPA settlements are against non-US companies. And 50% of all enforcement has been against non-US companies or individuals. So what comes out of this pause? The focus on transnational criminal organizations. Prosecutions where US companies are unfairly disadvantaged, or US national security, to include economic security, is at play. And to quote the Assistant Attorney General who's in charge of the criminal division at the Department of Justice, and the fraud section where the FCPA unit is sits underneath him, he said that this is about vindication of US interests, where it hurts the ability of U.S. businesses to compete on the international stage. At the same time, you see a softening of what would have been traditional U.S. corporate criminal enforcement. Todd Blanche, who, as Fabricio mentioned, is the Deputy Attorney General, articulated that they were going to go after cases that involved large bribe payments. Okay, nothing really that new there. Where there was some indicia of fraud, where there was an attempt to cover it up, to obstruct justice, where the bribery scheme looks more like a traditional crime than what was a lot of FCPA enforcement, that you entertain doctors, you have been paying, leaving the facilitation payment exception aside, you'd been paying small amounts of money across the board to get visas for customs clearance, and just to kind of make things easier, because what he said was that we're not going to focus on routine business practices, or as he referred to them as business niceties. So you see that on top of this layover, this landscape, you also have kind of a softening. Now, the Deputy Attorney General also said there would be a focus on individual prosecutions as opposed to corporate prosecutions. There's nothing really new there. DOJ has been saying that since I was a federal prosecutor and we rode dinosaurs to the office. So there's nothing really new with that. But what is new is, because I'm sure you're all aware, respondeat superior in the United States, which is the hook for corporate liability, is that if anybody acting within the scope of their employment, which is a very broad concept, doing anything that could benefit the company, makes the company liable. So a bribery scheme quintessentially falls into that, right? A salesman selling something to a government is acting within the scope of his duties. That salesperson is selling, right? Does it benefit the company? Even if the company has said, and has an excellent compliance program, has said over and over, and he was specifically instructed not to do that, yes, that person might be doing it for his own commission and his own bonus, but at the same time, it benefits the corporation because they get the sale. So bribery is kind of the quintessential respondeat superior offense. It's almost strict liability in the bribery world. But what the Deputy Attorney General has said, and how he defines a focus on individual prosecution, is we're not going to go after companies unless there is some greater indicia of corporate misconduct. In other words, we're not going to go after companies because of the act of an individual. And that goes back to what he's saying. There's got to be a big dollar amount. It's got to have indicia of fraud. All of that, I think, is going to impact enforcement. Then you've got some other areas that will impact enforcement that also, around May, June, I can't remember exactly when, the Department of Justice came out with what it's going to be its white-collar enforcement priorities. And remember, the priorities are all about immigration and narcotics. So at the same time I'm saying what are white-collar criminal priorities, resources are being drained from white-collar enforcement, both at the prosecutorial level and the investigation level. And I'll touch upon that again in a second. The priorities are, and again, you go back, one of the interesting things about this administration is they have signaled everything before. So if you look at their white-collar priorities, healthcare, waste, fraud, and abuse. You heard that during the campaign. We're going after waste, fraud, and abuse. In the US, Medicare and Medicaid, large public health programs, that's a focus. Trade tariffs, right? Trade diversion, and that's someplace where we've already seen the Department of Justice spending money in their budget as well as the other agencies. Financial crimes, particularly those involving China, right? Again, not a surprise if you were paying attention during the campaign. as we've mentioned several times, transnational criminal organizations, narcotics cartels, foreign terrorist groups. And then coming in 5 out of 5, bribery, for the reasons that we had talked about. But as I mentioned, there's a real resource shift occurring at the Department of Justice as well, which is going to impact this. The FCPA unit at DOJ had about 30 lawyers in it in January. They're now down to 15. And remember, a lot of those 15 lawyers have now been retasked with going after transnational criminal organizations. The FBI unit that was dedicated to FCPA enforcement no longer exists. Those agents have been reassigned. The FBI itself has seen a lot of force reduction through the termination of people who were involved in the January 6th prosecutions, other prosecutions involving the prior administration. There's been a lot of push out and movement within the FBI, which is the main investigatory agency on these. The Office of International Affairs, Fabricio and I were talking about this before the panel. Far fewer lawyers in the Office of International Affairs, which is the office that sends out requests under mutual legal assistance treaties that deals with foreign law enforcement agencies. Far fewer lawyers there. Also kind of playing into this broader landscape, the National Security Division at the Department of Justice. Now, while they're going to be tasked with tariff enforcement and efforts to get around the tariffs, so kind of going up in that way, the corporate enforcement group within the National Security Division has been completely disbanded, signaling, again, less of a focus on corporate enforcement. The Klepto Capture Task Force, going after the proceeds of crime in the United States, has been disbanded. And the Public Integrity Section at the Department of Justice, which are the ones that focus on domestic bribery of political officials. That had 20 lawyers in January. It's now down to 4. So a lot of movement here. At the same time, impacting our corporate clients, there's a slight twist to the corporate enforcement policy, providing more certainty on declinations for corporations that voluntarily disclose. So and this is something that's been evolving over the years. So this movement is not a surprise and might have happened under any administration. Previously, there was a presumption that if a company voluntarily disclosed, it would receive a declination so long as there were not aggravating factors. But that was a presumption. Now it's a certainty, but so long as there aren't aggravating factors. So it's still a subjective decision of the prosecutors that you're dealing with. Again, so really incremental movement there. There's also a new whistleblower program at DOJ that is important for non-US companies, because the prior whistleblower program, which brought a fair number of FCPA cases, not that many that grew into full-fledged cases, but brought a fair number of investigations, only applied to the SEC. It was part of the Dodd-Frank whistleblower program. And that obviously is for companies that trade on a US exchange. This new whistleblower program extends to private companies, so they could be non-US private companies. Of course, the US is always going to need jurisdiction. It's not that anything goes, but it does allow people to gain monetarily from reporting a crime to DOJ. So kind of what has happened in this aftermath? Well, part of the president's order during the 6-month pause was to review all existing cases. And about 50% of the then existing FCPA cases have been dropped, mostly against US companies or US companies that have had their cases dropped, but not all. You've seen with the Bombardier case, you've seen it dropped against a Canadian company, a Norwegian company, a company in the Caribbean. Those that remain, I haven't counted them up, but a lot of non-US companies remain, but also some US companies and US individuals remain. The only new indictment or criminal charges filed since the pause has been lifted has been against 2 Mexican individuals. So I think that theme of, enforcement against non-US companies and individuals, to the extent enforcement is happening, is kind of playing out in what we've been seeing. So I think what this means, as I said before, is there's going to be an enforcement effort against non-US companies to the extent, because morale is bad, there are fewer prosecutors, there are fewer investigators, but the focus will be on non-US companies. I think the focus will be particularly on Chinese companies or companies involved in a deal with China, because that seems to be a focus of the administration. And I wanted to touch upon, and then you'll be happy to know I'll stop talking for a bit. I wanted to touch upon, though, the risks that are with the focus on transnational criminal organizations, cartels, terrorist organizations. And that risk isn't in the FCPA world. But as you designate, and the administration has already designated 8 narcotics cartels, mostly, I think, mostly or totally Mexican and Venezuelan at this point, but I'm not sure, as terrorist organizations. So the issue that raises, which I know can have some impact here in Brazil as well, with some organized crime here, if those groups are designated, is material support of terrorism. So it's not the FCPA at all. But what material support of terrorism does, let me give you an example. If you've assisted those groups in any way, it brings in the possibility of material support of terrorism, and it brings in also the possibility of private lawsuits in the US. So how does this play out in practicality? Well, imagine areas in Mexico where there are operations, there's factories, and that's controlled by a cartel. And you need to pay that cartel to get the trucks out. You need to pay that cartel for safety in that area, or they will do damage to your property, kidnap your people, kill your people. If that cartel is designated a terrorist organization, any money you give to them, you're now materially supporting terrorism, which is a very serious criminal offense. It also allows, if that cartel then, this is the easiest example, so I'll stick with it. If that cartel then engages in an activity in which it kills a US person or injures a US person, that person's family can then sue in the United States, not just the cartel. There's no good to sue the cartel. They sue the company that had paid the cartel. They sue the banks that had banked the cartel, or banked an organization that's knowingly working with the cartel. And that allows them to get triple damages, legal fees, and it's automatic jurisdiction in the United States as well by an act of Congress. So that creates a whole nother layer of compliance risk and due diligence into where are we operating with? Who are we dealing with when we're operating there? Who are the third parties? If we have a security company with our factories in areas that might be controlled by organized crime, or organized crime is prevalent, our security providers, how are they providing us with security? And a great example of this, and again, it's kind of an extreme example, is Lafarge. And most of you have probably heard about the Lafarge case, and Lafarge continued to run its cement plant in Syria in an area controlled by ISIS at the time. And to do that, they were paying off ISIS. And this led to all sorts of prosecutions for Lafarge, not just in the United States, but elsewhere, for essentially material support of terrorism, as well as dealing with, sanctions violations, dealing with specially designated nationals, dealing with designated terrorist organizations. We can talk about, but maybe I'll turn it over to others, about filling the gap. Will the EU fill the gap in any way, right? France, the UK, and Switzerland have said that they're cooperating on anti-corruption matters. The European Union, for money that comes out of that they've been given there now, have a anti-corruption group. The California Attorney General has said that he'll start enforcing corruption if it touches California. And of course, right here in Brazil, there's still active enforcement going on, and the World Bank and other development banks. So with that, I promised I would stop talking eventually. So that was kind of my thoughts.
Thank you, Rich. That was very interesting and very good to hear information from down the ground there. So I'm sure that's very insightful. We'll come back to many of the points you raised here, but I would like to turn now to Reynaldo, Goto. Oh, you want to go first? Okay. Raquel, I think it'd be also interesting to see your views in terms of the academia and public policies related in this shift in terms of enforcement of the FCPA, please.
Morning. I want to start by thanking the IBRAC Compliance and Investigation section, a lot of great friends here, especially Raquel for the invitation to be in this particular panel to discuss, I guess, one of the most important topics of anti-corruption this year. And my aim here is to bring the discussion from the very detailed and insightful presentation that which gave us on the pause and unpause of the FCPA and the general context of white-collar criminal policy in the US to the Brazilian context, to lend it a little bit more in our landscape. For one, I want to discuss this idea that has been really prevalent in our community, which is the spillover effects of foreign enforcement in our domestic sphere. And second, I want to discuss more on the filling the gaps part, which is how about our own domestic capacity in front of these changes that we're seeing in the general landscape. Well, that's for sure that the FCPA for decades has been the global enforcement engine of the world. It has helped to propel the OECD Convention, the Inter-American Convention, the UN Convention, and through enforcement against foreign companies, it has pressured the domestic systems to adopt corporate liability rules, internal control standards, and cooperation mechanisms. So economic self-interest considerations by the US have never been absent from the FCPA, even if it has long been framed as a moral project or just the good for the world. Think about the three mechanisms we are all very familiar with. One, the idea of leveling the playing field. That's pure also US economic interests, because the FCPA enforcement would pressure foreign rivals to narrow down the bribe discount for doing businesses abroad. So that's just one example. The second would be the extraterritorial enforcement exports US compliance standards into the global supply chains. So effectively, it has built a standard-setting power for compliance technologies, audits, analytics, you name it. Third, studies have long debated if the enforcement salience of certain actions increase where corruption affects specific sectors with both national security concerns, but also market access implications, such as ports, energy, defense, state-owned enterprises. This has been long debated as well. So seen this way, the 2025 move looks less of a rupture than a restatement of now explicit alignment with US competitiveness and national security lenses. And globally, we can say that the companies have felt the legacies of this FCPA era and the US push towards convergence. Convergence of rules, substantial rules, so similar prohibitions in the world, controls across jurisdictions, convergence of practices on DPAs, NPAs, leniency agreements, cooperation credits, joint settlements with national authorities or with international organizations. And this has led, the story goes, to much more coordinated cross-border investigations, joint non-trial resolutions. These all became more common. Now, the concept that seems to be really under pressure here is less the idea of economic interest of the US, but the idea of foreign domestic institutional complementarity, or the spillover effects, as I mentioned. So the idea of institutional complementarity sees this convergence of rules and practices as making the whole better than the parts, right? So that in anti-corruption, the claim would be foreign enforcement, the FCPA, and domestic enforcement, such as our own anti-corruption legislation, would pull in the same direction, boosting detection, corporate incentives to self-report, investigations, so on and so forth. And this would happen because foreign institutions would have coercive force, they would have resources and expertise, maybe better information at times, no local political obstacles, and the domestic enforcement could act as a way leaning on the foreign, its foreign partners. But of course, this tale has gathered through the years a number of cautions, and maybe they are making the 2025 changes are making them even more important and more salient. For one, general attempts to shore up legal institutions from abroad has a really failing record if you look in general, not only on the anti-corruption field. There's ineffectiveness, there's no treating the root causes, and of course self-interest, as we discuss, makes externally driven efforts always a rocky situation. And second, there's a number of substitution risks. So strong international external enforcement can displace domestic local capacity in ways that are not necessarily productive for the general anti-corruption effectiveness. Third, and of course, institutional complementarity has always been uneven terrain. So looking at the 2022, already a little bit outdated maybe, the Exporting Corruption, TI's report on domestic frameworks against foreign bribery notes that only 2 countries were considered at the time, and that's data from 2021, active enforcement or enforcers. That would be the US and Switzerland. 7 would be considered moderate enforcers, Germany, the UK, France, and 18 limited enforcers, including Brazil. So the idea of institutional complementarity has always been, frail for a number of reasons. And what the 2025 changes seem to really add to the picture here is to fragment this institutional complementarity thesis, both in these ideas of coordination, joint settlements, joint investigations, but turning the international anti-corruption system much more into a patchwork than it already was. So maybe where interests align, and maybe where there is action, as which said, we might see some reinforcement between in foreign and domestic institutions. But where they don't, gaps will appear, and compliance in general should assume asymmetry and not harmony across forums. But even more importantly, the consequence of this demise of the institutional complementarity thesis should look more closely to domestic capacities from other countries, which has, of course, talking to a Brazilian audience, that seems very obvious. But if you look at how we study corruption in general, we are very much focused. We have been focused for so many years on the U.S. and on FCPA, on the FCPA. So just looking, just recapitulating some things that might be very useful and common for this audience. Brazil has spent decades trying to build incremental anti-corruption capacity. Think about corporate liability, the CGU, AGU architecture, audit courts, the MPF civil suits, criminal tools. And after the 2014-2021 surge, the car wash investigations, and subsequent recalibration, let's put it like that, more recent years are bringing trends that we should pay attention closely. So for my last counts, and using a paper published at the CGU Journal, until 2023, we had over 142 cases brought under the anti-corruption law. From 2023 to 2024, we had almost the same number in new cases. If this is correct, we can note there's more intensified action there, even if we can debate the scope and the reach of these cases. For instance, the numbers of proposals of leniency agreements have taken a downturn, we all know that, indicating that there is hesitation for self-reporting, there is still problems and hurdles to really look at. Also, 2025 especially is bringing moves and changes in the terrain that we should pay attention, that the compliance community should look at. One is the leniency coordination we've seen in April 2025, including the CGU, AGU, MPF, the cooperation, the technical cooperation agreement that has set the ground, at least, to coordinate negotiations and reducing domestic fragmentation that previously was a strong deterrent for companies to actually come forward, and promising more investigations and joint investigations across the board, including information sharing and also increasing confidentiality safeguards. We should look at that and see how this will develop. Second, we have seen some market activity indicating that agreements continue in 2025. Some interesting agreements that have been signed already. We have some new rule clarities, both the CGU, AGU leniency procedures to increase certainty and transparency for leniency agreements, but also the National Council for Public Prosecutors putting out a resolution for the non-civil persecution agreements, acordos de não persecução civil, in improbity cases, which we all know can be very much related as well to the general framework of corruption illicits. But not only we're seeing more streamlining in rules and procedures, we should take a look at that. We're also seeing now, and just the last few weeks, we are seeing some reinforced signals on legal entity accountability. We have seen multi-agency actions targeting the INSS-related fraud schemes. We are now entering a new phase where this will become in the political sphere with a new parliamentary inquiry on that, which can underscore an appetite for broader action touching companies and intermediaries on that front. Of course, we should, however, remain conscious. The Brazilian domestic enforcement landscape has a number of challenges and difficulties to navigate, including the incentives, the data sharing choices, the different conducts of the authorities, and of course, just playing out institutional capacity. The recent past has shown that our own domestic challenges can be massive obstacles in terms of accountability, as well as even bringing to the front questions of legitimacy of the anti-corruption framework. So we should be vigilant of our own institutional building And of course, just as it was mentioned, throughout the day, there will be many of the coming panels touching on specific themes on how we can grow and discuss more institutional building in the country. So, but my message here today would be, even if the US reinforcement is re-aiming or even taking a downturn, as which is mentioned, Brazil's domestic enforcement landscape should not be taken as it was in 10 years or 10 years ago or 5 years ago. For businesses in Brazil, the Brazilian anti-corruption framework will matter much more than it has in the past. But of course, the effectiveness and legitimacy of this anti-corruption regime remains a task for us, for all of us, in our different positions to further develop. Thank you.
Thank you, Raquel. And thanks for your comprehensive analysis of these implications of the shift of the FCPA enforcement and what are the spillover effects that we have here in Brazil. Very interesting analysis. So I'll turn now to Reynaldo, I think, also to address some of these issues, but also in a perspective of a multinational company, and how do you see this playing around in practices?
Okay. Thank you very much, Fabricio. I take the advantage to thank you very much to Soraya and Juliana for the invitation. Congratulations for the organization. Yeah, I just have a small pool here. Who is not a lawyer here? I'm the only one who's not a lawyer. So I need to nominate, true, okay. I need to nominate a lawyer to defend myself. Yeah, in case I do some stupidity here. Yeah. I'm not talking on behalf of BRF, but only some experience related to the topic, yeah. So thank you very much. And I have 3 points regarding the FCPA pause and unpause. And the first one was a conclusion that we had in Paris during the OECD convention, the OECD anti-corruption event on March, just after the first memo, the first executive order, as was mentioned, yeah. And I think that the first discussion that we had in Paris was exactly that no rules doesn't mean no sanctions, yeah. There's a difference between that. It's not the case that you don't have a rule, that is that there will be no sanction, yeah. And therefore, we need to keep vigilance, and the sanctions will come, but the problem is we don't know exactly how it will come, yeah. But another discussion that we had also in Paris is that although usually the law firms and the investigations firms was a little bit optimistic, yeah, I was not, or the majority of the companies was not that optimistic in terms of big cases or I love the way that you rephrased it, that's the car wash recalibration, yeah, because that was also one thing that I mentioned when I moved from Siemens to BRF in 2018, and I always mentioned I don't expect that much large investigations I was in the past with 100 custodians and tons of papers related to big cases. Of course, there will be one or other big case in the year, but not in the modus as it was in the past. Yeah, I think that we have a long-term friends here for the antitrust matters, and in the antitrust we have more or less the same thing. Yeah, we have huge cases, and nowadays I believe that at least the private sector is better educated on that. Yeah. Nevertheless, as Dr. Raquel very well mentioned, yeah, this soft power from the U.S. Legislation also has international influence. You mentioned the OECD Convention for '97 or the United Nations also convention, yeah. And in this discussion in Paris, we also mentioned that the UK, France, and Brazil also have not only clear legislation related to that, but also clear sanctions also related to that, yeah. And therefore, yeah, the first thing that I would like to mention is that no rules doesn't mean no sanctions, yeah. And another concern that the listed companies have in the US is not only the FCPA sanctions, but mainly the class actions, yeah, that are running, yeah. And that's also a matter that also concerns most of the companies, yeah. The second point that I would like to bring is that complaining without action can turn a challenge into a crisis. So we complain a lot in Brazil about lack of enforcement or downgrades or, as you mentioned, car wash recalibration, yeah? But that also turned into a crisis for us, yeah? So after the executive order, the US trade representative also started an investigation against Brazil, the Section 301, as you probably heard about it, yeah? We also need to present our defense on that, yeah? Next week, we are also going to be in US to defend Brazil related to that, yeah? And among the 6 points that was mentioned, there was also, yeah, the lack of enforcement related to anti-corruption, yeah? That, by the way, was not exactly the case, in my point of view, yeah? I would love to be here in the afternoon, but I have another appointment, but regarding this due diligence or the ESG agenda, yeah, I'm becoming more and more convinced that unfortunately this ESG agenda is being used for to bring some new barriers, yeah. And if you take the 6 points from the investigation section, we will have ethanol, deforesting, that's basically environmental, yeah, and even worse, the anti-corruption. So my point is the SDGs is becoming an environmental, social, and geopolitical barrier, not a governmental governance barrier for that. Yeah, and I'm very convinced that although we can complain a lot some issues about the anti-corruption agenda here in Brazil, we moved a lot. Yeah. We have a law for the state-owned enterprise. I personally participate in all the OECD reviews that took place here in Brazil, yeah, and I can mention very positive aspects on that. Yeah, we are the only country that 100% of the large state-owned enterprise has a compliance system. Yeah. We are the only country where more than 90% of the interviewed private companies also have a compliance system. Yeah? And we also have a law that's applied not only for Brazilian companies, but also to international companies. Yeah? I agree with Rich, yeah, when you mentioned that FCPA was also designed for non-US companies. Yeah? I think that most of us know that out of the top 10 FCPA sanctions, only one company is based in the US, yeah, out of the top 10. Yeah. But you know that Brazil also has more than 30 lenience agreements. I think that Marcelo could correct me, yeah, but I will have 34, yeah. But out of the 10 top lenience agreements, do you know how many US companies do we have out of that? 0. No US companies out of the top 10, yeah? And out of the top 10, we only have 3 international companies, one from Singapore, one from France, and one from Korea. That means that our law is working and also has this international enforcement as you also mentioned. Yeah? So my second point is complaining without action can turn this challenge into a crisis. And my third point is really, as we clear mention, that there will be a new focus on this agenda. Yeah, I think that more important that the executive order from February is the new guideline that was published in June. Yeah, and this new guideline is quite clear about this TCO, as we mentioned, this transnational criminal organization. Yeah, is also bring a new dimension, or there are 4 specific points in this memo, yeah, and I would like to bring the attention for the 2 last one. Yeah, the last one is the prioritization of investigation of serious misconduct, yeah, and stating quite clear that the U.S. government, the DOJ, is not looking for what they call low-dollar transactions, yeah. So the possibility of declinations is more and more affect, yeah, And it's also a point that we could discuss here in Brazil because mainly our sanctions are based, or the anti-corruption sanctions in Brazil, the calculations are based in the antitrust legislations, yeah? And it's quite hard for a company to make a disclosure if they have an investigation for a small dollar transaction, yeah, when the sanctions is extremely high, and you really don't have the incentives for that. Yeah. I'm not saying that you don't need to investigate, and of course you need to stop the wrongdoing, yeah. But the self-disclosures become more and more non-attractive if you don't have this type of definition of the low dollar transaction. But the second part, I think that is one thing that we discussed last year deeply in the G20 here in Brazil. Yeah, I have the privilege also to conduct the B20 discussions of antitrust. Yeah, and we brought this definition of the green corruption. Yeah, I slightly disagree with you about this this connection of the transnational criminal organization with corruption. Yeah, because we have a huge agenda here in Brazil to fight against illegal mining, illegal deforesting, and illegal biodiversity exploitation. Yeah, I think that there are crimes that are surrounded by bribe, by corruption. Yeah, if you pay for licenses, if you pay for an export transaction, yeah, if you pay I understand that it's still a small transaction, but it has also another dimension because it not only affects, yeah, the market, but it also has a tax evasion and also affects the environment. And therefore, I truly believe that Brazil needs to put a focus on that. And I also slightly disagree with the focus on China, yeah. Taking also this memo from June, we can see that U.S. is focused in Latin America and in Africa. Yeah, I hope that the U.S. doesn't consider Brazil as Latin America, as you, yeah. But it's quite clear nominated the cartels from Mexico in that specific memo. Yeah, but I also understand that there are some waivers for some industries from the U.S. Yeah. And I can remember previous discussions that I have with my international peers, yeah, like the car industry that were extremely concerned about the sourcing or the due diligence of their batteries because they are not very sure about the source of the critical mining, yeah. And critical mining is one specific field where it's clear detailed in this memo from the US, yeah. I also recall some discussions with international companies about construction of deep harbors, and there's also like a example of waiver that is described in this memo, and also international infrastructure. Yeah. And therefore, I understand that yes, and those are fields where the U.S. companies lost a lot of market share compared to the Chinese companies. Yeah. But I think that there are fields where I don't see a big focus on that specific point. Yeah. But on the other hand, I fully agree, yeah, that we need to be more concerned about the due diligence that we are doing, mainly here in Brazil, because we know that there's a lot of informal business here in Brazil still, yeah, and it's quite easy that you touch some financial resources from the transnational criminal organization, and that's one field that I think that we need to pay attention on. Okay. That was my initial thoughts.
Thank you, Reynaldo. Very interesting and practical points too. You come back to a few of them. So I think now we turn more to a lively discussion, on a Q&A section. First question I would like maybe to address to each. It's more like I don't want to get into legalese here, details. We are most lawyers here, but don't want to monopolize the topic here. But I think it would be interesting to hear from you, Luigi, on a purely legal perspective. I think many of us have also U.S. legal education here, but it kind of struggles me a little bit to understand how, in terms of the legal hierarchy of the laws, an executive order from the president can suspend the enforcement of an act enacted by the Congress, right? I think we would have a little bit discussion here in Brazil if we had this. It would probably go to the Supreme Court. So I first would like to hear from you on the legal analysis on this specific point.
Sure. I mean, just at the most basic level, Congress passes laws. The executive branch enforces laws. They are charged with putting the acts of Congress into action, so to speak. And the president sits at the top of the executive branch. The Attorney General and everybody who works for the Attorney General, theoretically, work for the president. And so if the president decides not to enforce a law, that theoretically is problematic, but there's nobody to really stop it until it would make its way through the courts. And where you see it, and you see cases making their way through the courts right now, where Congress has enacted spending, and the president has decided he's not going to spend that money. So people impacted by that have sued saying you can't do this, and those cases are going through the courts. Now, again, practically in a criminal context, who with standing is going to sue? I've been paying bribes and you're not enforcing this against me, right? Perhaps somebody could say I'm a victim of bribery and you're not enforcing this, but you get into all sorts of issues with standing with the courts in order to do something like that. So even if you could be successful, it's a very long route. And now coming back from the pause, they're not saying we're not going to enforce this, right? They're just saying our enforcement priorities are different. And again, you could have a legal challenge to say that's not what the statute says, right? Coming back to the intent of Congress. But, you know, right now it seems like they are well within, you know, coming back, they're well within their prerogative as to how they're going to enforce this particular statute.
Thank you. So now we're going more like to the substance here, and then address all of you to have your own views on that, which is, I think each of you mentioned like also USTR Section 301 investigation, which indicates that, I'll quote here, Brazil's efforts to fight corruption have weakened considerably in some areas. On the other hand, the executive order from the president we just mentioned that suspended the enforcement of the FCPA states, I will quote here as well, current FCPA enforcement impedes the U.S. foreign policy objectives, and the president's foreign policy authorities is inextricably linked with the global economic competitiveness of American companies. So it looks to me, I think each of you touched a little bit on this point. It seems that the FCPA enforcement now is shifting to other goals, not only combating corruption, and it's not me saying this. It's written there in the memo and the order, like maybe some trade issues related to this. So my first question would be on this, like, does this shift of the FCPA enforcement under the current administration of the U.S. Mean more a matter of foreign policy trade rather than combat corruption? And it will sound a little bit provocative here, but as you also mentioned that U.S. companies have been facing less investigations than the past. So does this like America first agenda means now American last in terms of FCPA enforcement? So how do you see all these other goals playing around here in this discussion of FCPA enforcement from now on.
So I think I'll add this. I think there's a difference between whenever we discussed FCPAs as a self-economic interest, and now what we seem to be looking as a plain display of power and weaponizing the anti-corruption system to other objectives, as you mentioned. I think this really jeopardizes the architecture of anti-corruption laws in general. And I think that's the biggest problem. Of course, trade tariffs are a huge problem, but if we want to get down to the real problem, I think it will be it, yeah.
I see from a different perspective, yeah. I see more like a negotiation tactic, yeah. Of course, there's a strategy behind it, yeah. But even the fact that you have a pause and an unpause, yeah. When you are playing poker, is like you are collecting all the cards and distributing again, yeah. It means that you have an opportunity to renegotiate or to bring a new person in the table to negotiate, and of course, from the other side, they are going to say, okay, I have a new opportunity here, but I need to understand what are the new rules or how the cards are redistributed. Yeah, I think that also in the section 301, yeah, we need to separate it. What is some issues that really we need to put a focus on that, and what is really some topics that are only put there to be negotiated at the end of the day. Yeah, and we know that, and it's not only with Brazil. Yeah, you look for all the other countries. Yeah, from day to night, they simply change from 0 to 50 or from 50 to 30 because there are some negotiation that, and more important, yeah. And one thing that I didn't mention before, one specific field that we are still not looking at this moment, but has a big impact when you distribute the cards again, yeah, is that you can have really serious movement inside trading. Yeah. You need to remember that if someone has a information or a privileged information that a tariff is going to be increased, or if one specific country is going to be blocked, then in the international chains, it has a huge impact in terms of stocks, price, advanced payments, yeah, and of course the price of the stock market from the companies, yeah, and that's one thing that we really need to observe, yeah, and really to understand, yeah, who could use this information in advance, or who is winning a lot of money out of that, yeah. And as was mentioned, yeah, some of the arguments are completely nonsense, but some of them, yeah, are just put in the table just for negotiation.
I think to a large extent, a lot of that was just pretextual. I'm swimming out of my lane into being a trade lawyer right now, but in order to use those emergency powers, the president has to state some sort of emergency and national security interest. So in order to promulgate tariffs, as Reynaldo was pointing out, for a negotiating tactic, and I think that's exactly right, got to create some sort of, or state some sort of emergency, and that, I think, was basically what that was about. In the broader issue, if we see FCPA or any large criminal case as it's been traditionally prosecuted, it would be a very blunt and bad instrument to try to quickly move the policy of another nation, because typically these cases take years. And they have promised, the Deputy Attorney General has promised that the cases will move faster. But to make a proper criminal case, and let's hold on proper for a moment, you have to get documents from other countries. You have to do mutual legal assistance treaties. You have to interview witnesses. A lot of those witnesses will be in other countries. You need to get permission to go interview those people. It's not easy to build an international corruption case by any stretch of the imagination. So if the prosecutions went as they have typically gone, even if you try to make them move very fast, it's not a good instrument to kind of use on the poker table because it's going to sit there for a very long time. But I come back to proper. There's an old saying in the US that you can indict a ham sandwich if you want to. So there is nothing really to prevent a prosecutor from running into a grand jury on very little evidence and just indicting a company. Now, would the case hold up? No, not eventually. But that's about the only way I see using something like this very quickly on the international checkerboard.
Interesting times. So I want to take a pause now to see if the audience would have any questions, and then we come back. Yes, Paulo, I think. I don't know if we have a microphone there.
Thank you very much. Thank you, Fabricio, for letting me make the question. It's actually two questions, one for Reed, one for Raquel. They are connected to the idea of path dependence. I mean, that institutions, they change, but they don't change completely from year to year, administration into administration. The first one would be to Raquel. I mean, we had a podcast when we talked about the car wash investigation. And in that investigation, we do very important developments in Brazil, there were impacts of the US FCPA application in the companies and the acts that were investigated in those investigations. I mean, maybe, Raquel, you could talk a little bit about how this worked in the past, and how do you see in the new enforcement priorities of the US this kind of the same rules, but in different enforcement settings being applied in a new situation in Brazil where nowadays, considering that we have a more focused activity of the US authorities in criminal organizations, especially those involved in drug trafficking, and we see in Brazil at least to several reports that these organizations are not anymore only active into drug trafficking, but in other kinds of economic activities in the country, in several areas. How do you see, I mean, considering the lessons learned from the past in the car wash investigation, how this could work in a new environment where we have, I don't know, the PCC renting apartments or working on fuel distribution or whatever, and as Reynaldo has mentioned, I mean, in the day-to-day business of companies operating in Brazil, these kind of situations may happen. And to each, to the extent that we see tariffs impacting the degree of connection of the US economy with the rest of the world, potentially limiting or making the US economy less connected to the world, I mean, in a simplified assessment, how do you see the impact of this that will likely be present not only in this administration, but again, on a path-dependent perspective in the next administrations? How do you see this impacting the extraterritorial effects of the FCPA or other similar statutes of the US, like sanctions, or, I mean, as you mentioned, I mean, maybe not only the FCPA, but other laws of the US may have extraterritorial effects in companies that are operating in the global arena. How do you see these effects in the coming years? Thank you.
Thank you, Paulo. Interesting, really, and difficult question. But here's a tentative answer. So path dependence will say that individuals change reality, but never as they intended, right? Because there are structures, and there are practices, and there are ethos, and there's a community, there's an epistemological community that says what corruption is and what is not. and so on and so forth. So all these changes, they come into a deeply not only regulated scenario, but also deeply entrenched into practices and just daily lives. So if we're looking at this question in terms of cooperation and international cooperation, I think the car wash years, for one, have taught a lot in terms of international cooperation for Brazilian authorities. And I will say just in normal formal cooperation mechanisms, if you look at the numbers, they are impressive, and then not only to the US, if we look at Peru, if we look at other Latin American countries, it has really, we have had some important lessons there in terms of learning how to cooperate better. Now, there's other story to the car wash investigation in terms of international cooperation, which is actually two other stories. One, which would be joint settlements, that was new. And that is, I think, an area where the executive order and then the subsequent refocus might change things quite a lot. And also the other area is direct cooperation or informal cooperation for us. And here we can see a big clash in terms of mentalities, in terms of how the US sees direct cooperation, how Brazil saw, finally, informal cooperation, and the moves it has been doing to kind of limit this kind of actions. So in terms of path dependency, I think we should not underestimate how much our authorities have learned to cooperate, but not only because the US is changing, but also we have also set some big standards there in terms of international cooperation. So I think the beauty of path dependency is that it shows that we don't know exactly how change is going to come, right? We can try to guess based on what was the past and what is happening now, but we don't know exactly. But I would say in terms of international cooperation, we know much more than we did, but we cannot do the same as we did in car wash. Yeah.
Are difficult questions, particularly from the home team. So that's, the immediate impact domestically in the United States, the first part of your question on tariffs and all, is going to be, one, how it's going to hit the consumer, right? Will the price of coffee go through the roof? People aren't going to like that. We really like coffee. How will it impact the stock market? That is the one metric the president really pays attention to. And it's the one, as you see, greater efforts to take control by firing the head of Bureau of Labor Statistics, like to take control of how the government reports statistics and things like that. It can't control the market. And so is there going to be an impact on any of these policies on the market? And if there is, that was where you're going to see the administration pull back, I think. From a broader standpoint on international cooperation and how this plays out, I kind of come back to the tenet, and Fabricio and Reynaldo and I were talking about this when we were having coffee earlier. It's far easier to tear things down than to rebuild them. And I think it impacts the broader kind of diplomatic defense world than law enforcement, although it definitely impacts law enforcement. But if you take a look at the US posture towards Europe, NATO, Ukraine, right? Even if the next administration, Republican or Democrat, is normal, I'll use the term normal, and things go back to kind of the normal post-war order, are you going to trust the United States again? Are you going to trust that the next administration won't go back to where we are now? So what are you going to see as a consequence? You're going to see, and you're seeing, right, the European nations building up their own defense, building up their own alliances with the idea that, well, maybe we can't rely on the United States. putting that into a law enforcement context, I think, Raquel hit the nail on the head with, we don't really know, but it's going to be different. It's much easier to put in place, okay, we're back, we're enforcing, we'd like your help. We have a common, there's a criminal here, we're both going after them, let's cooperate. That's easier to put in place. But those agencies are going to have to be thinking, 5 years later, is the United States still going to be cooperating with me? So I need my own capability there. And so I think you'll see very much, it might actually end up strengthening non-US law enforcement agencies, strengthening the capability of extraterritorial prosecution and investigation as opposed to weakening it. But I think it's one of those things that time will just tell.
Okay, so I'll now turn to a more specific and practical question in terms of the compliance agenda, because, I've heard from many companies here in Brazil and elsewhere with this shift of enforcement of the FCPA, also to discuss internally in the company, like in terms of budget expenses you should devote to compliance efforts. So should companies shift also their budgets to other compliance matters? It was mentioned here, ESG, or maybe now with combat of terrorism and also crime organizations, criminal organizations to, do the due diligence of your suppliers. We have many places in Brazil, like rural areas, that we know crime organizations very well organized, and maybe companies that have facilities in this place might have difficult times there. So my question would be, should also this impact, in your views, like the compliance agenda in companies, and how would that work in practice, and your recommendations of that?
From my point of view, the political answer is no, but in fact, I expected yes. Yeah, I think that optimization in the structures are always necessary. Yeah, and then, but remember that we, as Raquel clearly mentioned, we came from a basis that was, everything was extremely exaggerated, I would say, yeah, and we need to come to a point when it's normal, but where is the normal? It's extremely difficult to understand. No, I don't see large investigations, as I mentioned in the beginning. Yes, I see that in several companies we need to resize or reorganize the compliance organizations, but the field or the matters, yeah, is becoming more and more complex, as you mentioned. Yeah, the due diligence process needs to become more sophisticated. Yeah. The business partner evaluations also, I think that is becoming more and more complex, yeah. And the money laundering issues is also one thing that we need to pay attention. But specifically for multinationals, yeah, the export controls, I think that is a critical issue that is nowadays more and more complicated.
Yeah, I think, practically, it's got to be a tough conversation internally, Reynaldo, with the business. My sense of the compliance landscape, as I mentioned in the beginning, I wouldn't do anything very differently. As I said, the first reason, statute of limitations is 5 years. So it will go into another administration, another Department of Justice, right? That's probably the most practical reason. But then I think there are some other areas where it ties in, anti-corruption compliance ties in with a broader compliance framework. And that even if we're talking about, we mentioned low dollar payments. Well, the employee that thinks they can make low dollar payments, well, what is a low dollar payment? And even though, I'm really just sending this man's family to Paris because it'll help me get the contract signed. That's just really facilitating the signing of the contract. It becomes a very slippery slope. And then it plays into how employees view themselves versus the corporation. Because once you kind of get over those hurdles, it becomes, well, I really should have gotten a bigger bonus this year, so what does it really matter if I fake my expense account or skim a little bit? So you start to go down a very dangerous compliance slope, I think, without, and I know you weren't suggesting that, but without kind of firm corruption compliance across the board, whether it is, official corruption, commercial bribery, or even internal fraud. There's also due diligence in the M&A sphere, right? If your company is going to be acquired or one of its divisions is going to be acquired, there's going to be due diligence, which will include anti-corruption due diligence. So my sense of this from a compliance standpoint would be stay the course. Now, I think Reynaldo makes a very good point that when you're dealing with the business and they're saying, okay, here's your budget, where should we be spending money? And a lot of that, right, we measure risk. And part of that risk is, what is my risk of getting caught? And if I do get caught, what is my risk of enforcement? I think that risk is down. And so as you're allocating budgets around risk, that's just natural. And as you're deciding how much money to spend on an investigation, right, where you might have said, well, we might voluntarily disclose this, or the government might find out I need to look at 20 custodians' data, I need to interview 25 people, that might be a smaller investigation now. And I realize I'm speaking against my pecuniary interest here, which is why so many lawyers come up from private firms and be like, everything's just fine, nothing has changed. But there is that kind of cost-benefit analysis that we always make in the compliance sphere. And so I think it's only natural that in making that cost-benefit analysis, companies are going to say, maybe we can move more into other areas of compliance like tariff diversion or transnational criminal organizations and away from the traditional anti-corruption.
Yeah, I'll just go with you, Raquel just mentioned. I agree everything you said, but at the same time, this matrix of risk might be more complex now because you're adding other goals on the table, right? So if before was just, I think that was back to Reynaldo's point, it was just corruption. Now you have other agendas in place and they cost a lot of money too. So, things I think are becoming more multidisciplinary in practice in the day-to-day life of companies in doing business in Brazil and elsewhere, right? But Raquel, please. Yeah, sure. Okay. So I think we still have a few more minutes, so I don't know if you have more questions. I think we have 2 there, so 3 maybe. You want to put all together and then we wrap up the panel here?
Okay, so I'll start. I have 2 questions and then they are connected with other panels we have today, and I think in which the matters will interconnect. We've mentioned a lot on how all we commented here can impact in the stock market. And the SEC is also someone in charge of enforcing the FCPA. And there have been a lot of discussion on how the Department of Justice is somehow reorganized, but I at least have not read a lot on how the SEC is equipped, changing, or somehow reacting to these changes. So one I would like to hear about is, so what do we expect from the SEC on the enforcement of the FCPA and on the enforcement of the other indirect issues we've mentioned here? And also, I think it goes around in the same line of the question that was already posed, but we mentioned on how hard it is for organized crime being mapped in third-party due diligence, and maybe it's a practical question that's going to fall onto Reynaldo, which is a lot of the companies have designed their third-party due diligence process in order to understand if there is politically exposed persons there, how are the interactions between those third parties and the government, and so on and forth. So the risk has always been on government relations. So how are my third parties related to the government? Once the risk on the FCPA is, okay, how are my third parties connected with organized crime? How could companies somehow redesign their existing compliance programs in order to map these relations with organized crime, which is never so clear, especially if the enforcement could be erratic, as Raquel said, in a sense in which FCPA enforcement could be weaponized. I will steal the expression, which I think it fits well. So, for example, if the commerce says one company should be enforced, maybe it's easy to find a third party from such company that has any relation or any ties with PCC, for example. So how would you see to reorganize compliance programs in this regard?
Let's get the other questions and then we wrap up here.
Okay. Hi. I have one question specifically towards Mr. William, and talking about past U.S. administrations. I have a curiosity about how this FCPA enforcement, this downgrades in FCPA body, how this has been happening, because in a sense that is this an unprecedented event, or have you ever seen this before as a federal prosecutor? That's one question, specific question, because we've seen here in Brazil during car wash litigation and prosecution that it was really a hype at that time, if you can say like that. And after that, when we changed Brazilian administration, it almost died. And I'm talking about that as a previous criminal lawyer, and the market sensed that, and we have that boom at the time, and now after COVID, we don't have this anymore. So in this comparison, what's your perspective? It's unprecedented, or if it has happened before?
I think we got the last questions there.
Hi. Well, in a scenario of growing geopolitical rivalry, especially between the U.S. and China, and we've been observing an increasing focus on cases related to China, and this seems to extend not only to the Chinese companies, but also to multinationals dealing with Chinese companies as well. So based on that, to what extent does the FCPA really risk being perceived or actually used as a foreign policy or economic coercion tool, and instead of like an instrument to combat corruption? And also, what risks do you see when we are talking about Brazilian companies dealing with Chinese companies and not being like somehow penalized by just because they're doing business with Chinese companies from this perspective?
Okay. Do you have a last question there, or finished? Oh, yeah. Sorry, Amanda. Go ahead.
Very quick question. So building on Goto's point on insider trading and also on Torres, do you have U.S. experience on insider trading combined with corruption case? Because here in Brazil, we have a struggle on the administrative sphere on our SEC, but also being challenged on the judicial body. So I was wondering, because we have one graph, I don't know if everybody saw, when the tariffs were announced, there was a very different, I would say, market movement, and it was implied that maybe that was an insider trading case. So that could link insider trading with corruption. So I was wondering if that would be a new trend, a new perspective, or if we have past precedents. Thank you.
So I know it will be challenging, but I'll give you like 2 or 3 minutes for each of you to wrap up all these questions, easy questions, because we already have our next panelists here. So let's just try to wrap up the panel here, please.
It's like a game show. This is the rapid fire round. So the SEC has said that it will follow DOJ's lead on this. So I would expect enforcement from the SEC to just kind of follow along in terms of the same things we've been discussing. Overall, SEC enforcement, you've seen in the crypto sphere, they're not going to be enforcing as much there. That's been a stated policy of the government, but I do think you'll still see bread and butter, insider trading enforcement, accounting fraud enforcement, just kind of its traditional docket. Organized crime, politically exposed people, that's almost a better question for Reynaldo, but I would suggest you have the due diligence framework. It's risk-based, and when you're looking at third parties, it's risk-based due diligence. Who are they? Where are they operating? What are they doing for you? And how deep you kind of dive into that. Is this an unprecedented event? Administrations come and go, as you were saying, but in FCPA enforcement, it's been up and down, hasn't really been tied so much to an administration. And one of the things that we always say is these cases generally take 3 or 4 years to make their way through the pipeline. So if you see like an uptick in a Democratic administration, a lot of that is cases that started under maybe a prior Republican administration and vice versa. So it goes up and down, but kind of the enforcement priorities, except at the edges, have always remained the same. I can say there's been a lot of criticism over the years in the United States that we have come to prosecute what are really regulatory offenses. And I think this administration, not just in the FCPA area, is kind of grabbing a hold of that notion and saying, look, a lot of this should be handled civilly, regulatorily, and not in the criminal sphere. Finally, not even finally, geopolitical rivalry. As I said before, I think it is a blunt instrument to be the FCPA because it takes too long. It's too hard to wield. Having said that, right, you asked very specifically, like a Brazilian company dealing with a Chinese company. What I would focus on is who are the other companies involved, because the enforcement is going to come if you can say a US company lost out on that transaction because there were bribes paid, right? That's really the kind of what the administration has been saying is the sine qua non of enforcement. Insider trading connected with corruption cases, not really. Our insider trading law is very complex and requires like a fiduciary duty, and I could talk about 10b-5, and it's complex. We've seen cases tied to members of Congress and their staff where they knew something, you know, the government was going to do something, and they traded on it before the government did that. Only a handful of cases. For the most part, it's more like traditional insider trading. I'm not aware of anyone being tied to like knowledge of a corruption case.
Or to
Yes, so I think I'll just comment one thing on insider trading in Brazil, which, just to compare with the anti-corruption framework, we have seen a really dense, you know, a lot of our institutions building capacity for anti-corruption. Now, insider trading is a little different story. And what we should pay attention, if something we have learned from the anti-corruption framework, which is to pay attention between the interactions of institutions and how they can work or not, I think if insider trading becomes more of a trend, we should pay attention from between the interactions of CVM and the Public Prosecution Office, because that's a very different one than what we have seen in the anti-corruption field. Yeah.
I think that's subject of the due diligence for another topic, but I would say that be serious, be bold, but don't be naive. Yeah. Don't be naive, because I think that Brazil is taking it really seriously. Yeah. And if you take also international legislations or international examples, yeah, in Europe, I don't see that's really a good example, because they failed to pass the first suggestion. The second one, okay, yeah, was approved, but not all state members applied the law. And even the SEC that was mentioned took a public consultation that took a while, and they were not able to implement a standard like ISSB that we implemented here in Brazil. And Brazil, by the way, was the first large nation that implemented a standard for that. Similar for other legislations, I would like to mention that also Brazil was the only country that really provoked and really implemented a resolution from the United Nations Anti-Corruption Agenda from 2023 that was proposed by Brazil together with Saudi Arabia, that was to foster the compliance system in the private sector. And it's doing quite well, I would say. Yeah. So therefore, I think that we are a target, specifically in the due diligence, being quite clear, yeah, because we are a huge exporter, and not by accident, yeah. Some specific industries that have a markup, a special price for specific products like wine, like coffee, like clothes, yeah. I'm not saying that we are perfect. I'm not saying that we do not need to review our practice, but as I mentioned, we need to be bold, we need to be serious, but we cannot be naive also in this market.
Thank you, Reynaldo. I think with this, we finish our panel. It was a very interesting and lively discussion, which I'm sure will go throughout the day, follow-up discussion. So thank you very much.
Obrigado.